Thank you. Be seated. Good morning. Is it still morning? Now's the time set for oral argument in cause number 1CA-JV 18-0001. Mackenzie W versus Elliott M and BW. For everybody's information, these proceedings are being both audio and video recorded, so absent any technical problems, you'll be able to see yourself in a couple weeks on YouTube. Counsel, each side will be entitled to 20 minutes, the normal standard amount. We would ask that you respect the time period. The timer located on the podium will let you know how much time you have left, and for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will try and avoid taking up all your time. However, ultimately, your reserving of rebuttal time is up to you. We have reviewed the briefs. We have conferenced the case this morning. We are well aware of the facts. We tell you that so that you can figure out how you want to structure your argument. You might want to keep that in mind and use your time accordingly. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, the appellant may begin.
May it please this court, Michael Ellsworth on behalf of the appellant, the biological mother in the case, and good morning, judges. It's a pleasure to be here, but I'm glad to have this opportunity to advocate on behalf of my client. As noted there in the opening, I know this court's very well of the facts. There's just a couple of things that I'd like to point out. In regards to the facts, it's important to remember the child here was born on February of 2016. And as of the date of the trial, which was in September of 2017, that child would have been approximately 19 months. And as the court knows from the facts of this case, the child had been in the care of the mother throughout its entire life, and with mother's fiance living in the same household for over a year at that time. So approximately about 63% of the child's life had been in the care. And that's also, I believe, noted in the judge's findings in the order that the child did have a relationship with the fiance, called him dad, and that he was a great father figure in that. Now, this appeal today...
Well, I am going to interrupt you. Has Mackenzie and Dylan, have they married yet?
They have not. They're still engaged. And again, as noted, it was their intent and I believe the order reflects they were saving money to buy a house. I believe in the transcript they actually referred to they were saving money also for the wedding and to purchase a home.
And one of the reasons, and correct me if I'm misstating the record, but one of the reasons why the father did not have contact with the child is because of an order of protection that was in place.
And that's actually, I believe, incorrect. That was father's position, I believe, at one point. But on the transcript and what was brought out at the trial is the order of protection did not prohibit him from having any contact with the child. Yet, again, he took no action. But really what we're here today is about the best interest factor and not about abandonment, because that was found by the court and there has not been a cross appeal challenging that finding of the court.
One of the things we have to consider, and I'm sure the trial court considered, is the reasoning why there may have been a lack of contact between a parent and child throughout the course of the child's life.
In the trial court did note, and again, it was found in the transcript, and I just said it didn't specifically address that because of just filing the appeal on the best interest, was father, it was really his own inaction that resulted in him not having contact. One, the order of protection was in place, which limited contact with mother, but the child was not on that order of protection, and he waited a significant period of time to even try to assert his right as a father. And as we know from case law, he has to be proactive in asserting his legal rights.
And at some point in time he did request visitation, and mother was willing to give him contact, and they had contact for a period of time.
There was some brief contact that mother had agreed to. But again, as noted in the judge's finding and order, and I believe the language that the judge used was that father had significant issues, including alcohol issues, and there was a felony conviction also related to some domestic violence and the order of protection. And so, again, it was father's inaction or failure to take action to establish any type of court-ordered type parent-time revisitation, and also his own actions of limiting himself and be able to do that because of his alcohol issues and other issues he was dealing with.
Father did file a petition to establish parenting time.
He did. He filed that shortly before mother, in return after that, did file the petition to terminate. And I know there may be argument from the appellee on this of saying, well, this was in retribution.
It appears that way, doesn't it?
It may be on its face it does, but if we look at the circumstances, father was having very limited contact, wasn't trying to be part of this child's life. Mother and her fiance were working towards, again, getting married, building a house, those type of things. And so there wasn't at that point the need, because father's really lack of communication or contact with the child. So once he says, now I want to be part of the life, mother then steps in and says, well, hey, this really isn't in the best interest of the child. So then...
Child's best interest or her best interest?
Child's best interest.
So you're saying up until the time he requested to meet with the child or to be with the child, it was okay? There wasn't a problem with him visiting when he wasn't, but as soon as he asked for it, it was a problem?
Not that there wasn't a problem with him visiting, but there wasn't this need to go out and seek a termination because he really was non-participant in the child's life, which is reflective of the judge finding abandonment at that point. And at that point, prior to that, there was no court order. Visitations would be set by mom under the circumstances presented. And again, there was very little contact by the father, thus the court's finding of abandonment.
So when the father determined that he wants to have more contact and not have it at mom's whim or caprice, then she files a motion to terminate.
Then she does go in a separate matter with the juvenile court, files the petition to terminate based on what she believes to be in the best interest of the child, based on the stability that she can provide and her fiance husband will provide, and also based on the fact that child can now be adopted by this other party, this other man who has been the father of the child, which was the finding of the court, that he calls him dad, that he is a great father figure for him.
Well, he can't adopt him now, can he? Not married, that's why I asked you the question.
Well, and I would submit, and I believe I noted in there, I don't believe that there's anything that prohibits him from doing the adoption right now, even without being married.
Isn't there a statute that says that?
I may be wrong on that, but I don't know that there has to be a step that actually, and if I'm wrong on that, I apologize.
Are you looking?
I'm looking for it. I can't find it.
But the intent of
Isn't there a statute, counsel, that says if the child is adopted at a time when, you know, if the mother agrees to the adoption at a time, and I'm not stating this per the statute, but the net effect is if the adoption is allowed to go forward, then the adoptive father in this case would have been the parent, but mother would have given up her rights in the process? They had to be married for both of them to be able to claim to be the parent?
In that, I'm not sure. I have not researched. I have not researched that issue.
117B through C.
There it is, yeah.
You couldn't adopt because adoption would sever mother's rights unless they're married.
But under the facts of this case, again, that's what we're suggesting is he's the one that has that relationship. And that was mom's intent and was testified at trial. And that's the evidence, and that's the issue on the best interest that we get to is the trial court had that evidence before them.
The evidence, which evidence?
The evidence that there was this relationship with the fiancé, that it was the party's intent to get married, and it was the intent for that child to be adopted.
Well, the court considered that, just noted that, you know, it's going to be a while before he can adopt.
Right, but what we're suggesting is the court in doing that, in looking at the findings of the court and saying, well, it's going to be a substantial period of time before he can. One, the issue of how do we define substantial, that's hard to do. But the judge seemed to reflect as saying, because it's going to be a period of time before they can adopt, then I'm not finding best interest. But that's contrary to the case law.
Well, that's not the only thing she considered when she issued her order in
She-
that regard.
Correct. And she also considered, if we look at the findings, she considered and said, father now is in a position to provide support for the child and is in a position to care for the child. But as cited in our reply brief, the case of, it's the juvenile matter, action number JS1363, where the appellate court at that time made the finding and said, we believe the real question raised by the mother in this case is whether once the presumption has attached, it may be rebutted merely by showing of attempts to reestablish a parent-child relationship. After the petition was filed, we think not. As pointed out by the trial court in that case, the findings, a contrary conclusion would virtually eliminate any contested termination action. So the court, in not looking at this and applying that, in essence is saying, okay, well, if a parent steps in, we got the petition to terminate there. Now it says, hey, you know what? I'm able to care for, I'm able to pay support, even though I have not done that up to this point. Even though in this case the judge found he had abandoned, because I'm willing to do that now, the judge is going to rely on that factor, and I think that's contrary to what should be applied in regards to the burden of proof of by a preponderance of the evidence, and applied to this case in the facts, the father had not done those things, thus the termination or the ground for abandonment, and now we have that adoptive plan, and that's what Oscar O references to. It talks about a plan. It also references to immediate, but then it also references to a plan for adoption. How many times do we see in juvenile cases with DCS involved where there may or may not be a adoptive parent or person out there, but the child is found to be adoptable? And it's important to note in Oscar and the language from that case, and I would note Oscar is very, not the facts necessarily, but in theme as to this case is very similar, where in there it says that to establish the termination of parental rights in that case, the best interest, ADS was required to show that the girls would derive an affirmative benefit or incur a detriment. It goes on to say the existence of a current adoptive plan is one well-recognized example of such benefit. And that was referencing to a previous case. Also stated, even without firm plan of adoption, severance benefits adoptable children by freeing them for adoption.
I think that case law, though, doesn't really apply here, does it? Those cases, as I'm remembering them, universally arise in contexts where there is no parent. Here we have three adults who want to parent the child. Oscar and the other cases, there's no parent in the ballgame there. Here, I mean, how did the court abuse its discretion by concluding that at least as long as the fiance is legally unable to adopt the child is disadvantaged by having three loving adults who want to parent him?
Well, and not necessarily that the child is disadvantaged of that, but again, looking at our legislature and the statute that was written and applying that, and also applying this term of permanency, and I would note the trial court in itself referenced to the case of Demetrius, which was a 2016 case. What the court did, though, is the trial court took about 2 lines out of that. But if looking below that, here's some interesting facts or interesting findings of that court. And it said, in the best interest inquiry, however, we can presume that the interests of parents and child diverge because the court has already found the existence of one of the statutory grounds of termination. So that court found in that case, the court already found termination or found abandonment. Now the court can already presume that the interests of the parents diverge.
But that's rebuttable.
It is. Then it goes on to say, thus, in considering best interest, the court must balance the unfit parent's deluded interest against the independent and often adverse interest of the child in a safe and stable home life. and this is the important line I'd like to stress, where it says, of foremost concern in that regard is protecting a child's interest in stability and security.
And what's harmed here?
Well, that interest of stability and security is being adopted and living in a home with the mother and father.
He's living in the home right now with the mother and the fiance.
With the mother and and yes, with the fiance. But again, best interest has been found if there is adoptive placement or an adoptive parent-adoptive plan, that provides permanency and stability. And I would disagree a little bit, Judge, to say, well, we have to exclude DCS cases from these other cases where maybe we've got a child with a parent here, because there's still that permanence for the child. That's belonging to that family as a husband and a wife.
But Mr. Ellsworth, you're still losing me a little bit on why he's disadvantaged because there is another adult out there that wants to love and care for the child.
Well, and maybe if I may, Judge, and let me grab the transcript real quick. And what we're saying is, I believe the judge in the trial case maybe was looking at it in that same way, which we believe is the wrong way to look at it. Because the court, on page 172 of the transcript, this was during the closing argument, said, but I have to find best interest, not just good interest. And it appears from the line of questioning that we're trying to say, okay, how is the child, how are they in a worse position, or a better position to your question of saying, what detriment is there by keeping him in a household with 3 children?
No, I didn't. I said he's going to remain, the child is going to remain in that household and have parenting time with another adult that loves and cares for the child. How is that a detriment?
And that's my concern, and how we believe the trial court looked at it too, is saying, okay, how is that a detriment if we keep this relationship? But isn't the burden of proof here, by a preponderance of evidence, whether there is, as stated in these previous cases, is there an affirmative benefit by the termination?
Well, what's the benefit?
The adoption.
He loses one. He remains in the home that he's living in now, but he's without the ability to engage with a loving parent.
Well, the affirmative benefit, judges, it's been repeatedly found that an adoption is a benefit to that child. And as I stated in Oscar O.
See, I think maybe the comeback to that is a permanent family is an advantage, there's a benefit to a child who lacks a family. This child has a family. I mean, from the mother's perspective, he has too much family, I would suggest.
And I would suggest, I don't know that the language in Oscar O delineates that, of saying that. The language is very specific there of this benefit that can be derived.
Is there a real parent in Oscar O that's still in the picture?
There was not. Both mom and dad's rights were terminated in that case.
Counsel, doesn't the court also confront a difficult situation where we're talking about terminating the natural father's right at a time when mother says, well, we really can't adopt right now because we're waiting to get married until we have our home. That was the circumstance, correct? We're not going to get married until after we have a home, and there was some discussion about paying for the wedding and all that. And yet what the court was asked to do was to thin the supportive, and when I say supportive, I'm not talking about the feelings, the emotions. I'm talking about the finances. We're going to get down to where there's one parent that's responsible for this child, and if the fiance never becomes the husband, we've got an issue, right? We've got a mom. We've terminated the father, correct?
If we've terminated the father, yes.
And there's one person that's responsible for this child, and the statutes say that a child is entitled to the support of 2 parents. So wasn't the court also kind of notating, if you will, the notion that until there's something more than just a promise that we're someday going to get married, that this child deserves the support of 2 parents?
Well, and that may be what the court was reflecting on, saying there'll be a substantial amount of time. But again, what I'm suggesting is, and the appellant's suggestion is, based on other case law, the courts have repeatedly found that if the child is adoptable and there's an adoption plan. But what we have a situation here, Judge, is we're going back to of saying, okay, what statutory ground do we have? We had abandonment because father had not been supporting the child. That was the case.
Well, why are we here? We're here because the natural father's saying, look, I may have goofed up for 12 months from, February of 17 to February of 18. I didn't see him. Okay? But I want to. I want to be the father. I want to do all these things, and I'm not willing to just walk away and be severed. I'm just saying, isn't it possible? The court's saying, well, you know what? Maybe we need to hold off on this until we have a cutting the birth father's ties until we have someone else that's in a position and bound by law to support this child.
And that may be the thinking, but I believe that's inconsistent with previous case law and the finding of best interest. And I understand, again, from what you're saying that you may not agree with that, but I think if we look at the best interest specifically, by a preponderance of evidence, at trial, there was no evidence. Mother made a finding, the court made that finding to say father is now able to support. But if we look at the past history, he's never done that. So the court's assuming something that the court does not know is going to happen, yet it had the evidence in front of it of saying, here's somebody who has been there. It is their plan to adopt. And this is who has been the father, yet still by that burden of proof was not willing to terminate the parental rights. And I believe, again, Oscar, and I know I'm out of time, but if I may, just the last thing there in Oscar, and that was an interesting case because very seldom do you see the Court of Appeals, I believe, at least from my research, to go and say, Judge, I'm telling you what to do when we send it back to you. But the last paragraph in there says, although juvenile court clearly had authority to deny severance when the best interests of the children will not be served, thereby the court have here articulated no reason for the finding, nor does the evidence supply one, having researched the record in vain for reasonable evidence to suggest that severance and adoption were not in the best interest, the finding clear, convincing, and virtual uncontroverted evidence of the record to support the opposite conclusion. The trial court there, the appellate court there said, we reverse the order of the juvenile court, remand the case with direction, and grant the motion to terminate parental rights. They just didn't send it back and say, Judge, you need to reconsider this. They told the court what to do there, and we believe that's similar to this in that they're uncontroverted evidence that it's in the best interest of this child for permanency because of the adoption and the person that's out there that has been father. Thank you.
Thank you, counsel.
Good morning. May it please the court. I'm Eduardo Coronado, and I represent the appellee, Mr. Elliott Merkel. This case really is about a father that wants to be involved in his son's life, and about a court that found that way. It found that way, even though it found that he had abandoned Branch. That it was not in the best interest of Branch to sever that relationship between a son and a father. Mr. Merkel did have some issues, clearly, for that first year of his son's life. The court found that he had some alcohol issues, but then the court clearly found that he had worked out those issues. Clearly, he woke up from whatever stupor, whether it was a drunken stupor or just out on some slumber enjoyment of 1 year. He woke up in February of 2017 and realized, I have a son. I want to continue. I want maybe not to continue, but I want to be a part of his life. Mother, the appellant, figured that was actually good for Branch. The court found that she said that and agreed to allow that possibility of cultivating the relationship. And there were at least 6 parenting time occasions where Mr. Merkel engaged with Branch. Mr. Merkel then decided that, look, I'm his father. I want to be part of his life, and the way to do it is not necessarily to always be asking mother for permission, but going to court and establishing that, so that if there's ever an issue, it's in writing, it's a court order, and my parenting time will be respected. Appellant then realizes, oh no, I'm losing control, and files a petition to terminate his rights. So it's not, I know that the appellant wants to say and paint a picture that termination is happening and Mr. Merkel decided to wake up. No, he woke up before, took the steps necessary to engage in his parental rights, and then mother, the appellant, realized, oh no, I can't have Branch for myself anymore, or whatever she thought, but it clearly looks like it's retaliatory. I know that the appellant wants to really rely on Oscar O, but I don't think Oscar O is anywhere near the case that we're dealing with today, for 2 very important reasons. One, the facts are so different. As the court was asking the appellant, there is no parent available. Both parents had checked out as parents a while before the 2 little girls in Oscar O were at the point of severance. There was domestic violence. There was other issues, drug issues, that were not dealt with when the severance came, and indeed the court severed. The other part of it is that Oscar O was, I would say, unique in that I'll agree with that with the appellant, that it's unique, but it's unique because the court kind of articulated all these reasons why it would found under the ground, but then didn't articulate why it was not in the best interest of the little girls for the severance. Even though it articulated all these issues, it kind of didn't move it from that column to the other. And the Court of Appeal said, wait a minute, you articulated all these issues that we have a problem with, but you're not applying it to the best interest? No, you've got to go and apply it. Here, the court did. The court applied all the issues, and then it came down to the best interest prong. And it said, it's not in his best interest because, one, I forget stepfather's name, so I think it's Dylan. They're not married. So it will be a while before they're married. So that's an issue in itself. And we're here today, almost 1 year, 8 months after the issuance of the order. Not 1 year after the hearing, but 1 year after the issuance of the order almost. Well, so I guess we're closer to the hearing date for 1 year, which is about 11 months. And they're still not married. And I agree with the court in that I don't think that the mother intended to file the termination petition so that her rights could be terminated, and I guess then go back and apply, so that then she can adopt along with her fiance. I can't think that that's what she meant. So that's one issue that the court articulated. The other two really are that father came around, and the father came around before any filing.
Isn't that supports the notion, I think, that perhaps there are cases that say that when the court finds by clear and convincing evidence a ground for severance, a statutory ground for severance, then we may presume that severance is in the best interest of the child. I'm not so sure that legal principle is always applicable in the case of a situation where the statutory ground is abandonment, right? I mean, sometimes the statutory ground is abuse, neglect, inability to care for the child. If the parent remains unable to care for the child, well, then there's grounds, and then application of that principle would make sense. But in a case where the statutory ground of abandonment is found based on the cases that say too little, too late, when the parent has reformed and wants to be engaged, I'm not so sure that the rebuttable presumption is very strong.
Well, Your Honor, and I agree. I think that that there's case law actually that talks specifically about abandonment and what the court is saying, that abandonment is kind of a very unique ground in that, in this case particularly, Mr. Merkel, the father, did something about it before the petition was even filed. That he did something about it without even thinking that mother was going. Well, that's our argument, that he wasn't even thinking termination. He just wanted to be part of his son's life. But going back to the other articulations that the court outlined, wants to be part of the child's life, and appellant states in their brief and in her argument today that that the father wants to. That is not what the court found. The juvenile court found that the father is willing and able, which is very different than Mr. Merkel coming and telling the court, I want to. Mr. Merkel has already not only articulated that, but has shown that even before the petition was filed. One thing that I don't want to forget to talk about is the appellant's assertion that their third issue specifically, that it's a de novo review. I disagree. I know, who cares what I think, but I'll make the argument. The appellant states the reason it's de novo is because the judge interpreted the statute, and therefore because the judge interpreted the statute, it's de novo. Well, I think it's a stretch, but even more than that, if the judge would have said 533 only states X, Y, and Z and clearly leaves out a part of the statute, then I would agree. It's de novo. Even though I wouldn't want you to treat it as de novo, I'd have to concede that it's de novo. But in this case, the judge didn't do that. The judge looked at the whole statute, applied the ground, and then went to the second prong and said, second prong doesn't apply, which is the best interest. Clearly, she applied the statute. And it's not an issue of interpretation. It's an issue of the appellant saying, we just don't like the way you applied the statute. Not that you just clearly didn't review the statute and left out a significant and important portion. It's just that you said it's not in the best interest and articulated those best interests. It just didn't come our way. And that's our position, that it's not a de novo review. I think that going back to the I, who cares what I say, but looking at Oscar O again, the appellant clearly puts a lot of emphasis on Oscar O, because the result is really good for the appellant's argument. But Oscar O doesn't really apply. The Court of Appeal stated, you didn't articulate to us why best interest was applied this way. Judge Rickle articulated why best interest did not apply here, or that it was not in Branch's best interest. She articulated it. That distinguishes Oscar O. Certainly the facts would distinguish it, but I think even the application, the way Judge Rickle applied the statute, is very different than how Oscar O, the trial court, the juvenile court, had applied it. The argument by the appellant that, specifically in her reply brief, that what the father thinks of the future doesn't matter and should be irrelevant to you, but then comes to court, specifically here, and tells the court, but when it comes to mother, I want you to really think about the future, because appellant's fiancé is going to marry her in the future and then adopt him. It's hypocritical of the appellant to say that, to say father's future doesn't matter, but mother's future does. And whether the father's wishes, future wishes, are relevant or not, and I would argue that they're not relevant in this case, because the court made findings that are specifically present-wise. Willing, able. The other reason she found for not in the best interest is because father has relatives that are willing and able to care for this child. So the court's concerned about a detriment. There is none. Child will have paternal relatives. The court found that. The child will have maternal relatives, and the child will have relatives that I'm sure are very loving from the side of the future husband of mother. There's just no detriment to affirming the court. There really isn't. So I know Mr. Merkel would really be thankful if you affirm the court's decision. The law is there and the facts are there. Thank you very much.
Thank you. Counsel, we do appreciate your argument today.
Thank you.
We are going to take the matter under advisement at this time, and we will issue our decision in due course. Thank you. We're adjourned.